you blow even a 0.0000001, you will immediately report to jail and you will sit the whole sentence, no good time.
Whoa, bang bang shrimp is a legal defense. Folks, this is not Red Lobster. It's a courtroom. And the judge just made it clear. No excuses. No food-based alibis. Do you think judges should be this strict, or does he sound a bit too harsh here?
No, Huber. I do not take, I was near rubbing alcohol. I do not take, I ate bang bang shrimp. I do not take that I ate tiramisu and it was made with real alcohol. Now, again, you understand that I'm not bound to follow any recommendation, and that would include following the IDIP guidelines.
Yes.
I could sentence you all the way up to the maximum possible penalty, again, if I thought it was warranted. You understand that?
Yes.
Do you have any questions for your attorney or the court before we proceed?
Sorry.
And that's all kinds of fun today. Okay.
Sorry about that.
All right. So you understand I could sentence you to the maximum penalty?
Yes.
Okay. Any questions?
Just one. It's just kind of a math question.
And here we go. The math class objection. Imagine telling a judge, "Hold on, Your Honor, decimals confuse me." Viewers, do you buy this as a genuine question? Or is this just stalling for time?
I just want to know if it's fictional or a fact.
Math is usually not fiction. Why,
Yeah.
it's math.
And yeah, so I'd just like to be explained, like, how the math works. So I'm pretty good at math.
Want me to get a math professor in here to explain it? Because I'm not a mathematician.
That's what he said.
That he's not a mathematician because he's not, because quite honestly, we go to law school, so we don't have to do math, but we have to do math in our job. What's your question?
Just to know if this is fictional or factual.
I don't know what this is.
Would you like me to?
No, what is this, Mr. Keene?
Yeah, I think it's great. The issue, and it's been up with Ms. Anderson, is he had a question about the grams per 100 milliliters.
Dude,
and
that's a scientific question. You can call up the scientists or the lab analysts that do that. I'm not in charge of that. And the legislature makes up the laws. I'm in charge of following and enforcing the laws.
Okay.
So what's your question? You think that you were below the limit, above the limit, beyond the limit, how they came up with the limit?
According to this, I was not above.
Okay, and that's like a AI chatbot thing, right?
Yeah. So
Yeah,
maybe it's wrong.
yeah, it is.
An AI chatbot?
But
Are we using artificial intelligence?
Wow, that escalated quickly. After all the decimal debates, he just folds. But notice what's happening. This is a moment where frustration overrides strategy. Ever seen someone argue themselves into jail?
it's just that I was measured in thousandths, and the law goes by hundredths.
We can have a trial if you want.
I am so great to have a trial. I love having trials, especially when the lab analyst comes, and especially when then it completely opens up to the maximum penalties. That's great and fine with me. Is that what you wish to do, and have a lab analyst up here to explain all of the scientific reasoning behind the calculations and behind their testing?
Just take me to jail.
Okay, I think that's his way of saying he's not rushing to press the point, Your Honor.
All right. Okay. So now, did you review the criminal complaint with your attorney? And it has all of those facts that says what happened that day from the officer's perspective and from your perspective, because you said, I only had 1 or 2 beers, which we know isn't factually true.
No, I had 0. I had drinking the night before.
So then you drank a lot more than 1 or 2 beers the night before.
I had a six pack of 16 ounces and a 16-ounce.
And yet you blew a .221, allegedly in the criminal complaint.
Yeah, and that's what I'm saying is that 221 is thousandths, not hundredths.
Oh, Mr. Lamprecht, it's .08 in Wisconsin to be legally drunk. And for 1 or 2 beers or a 6-pack or whatever you said the night before, unless you are a chronic alcoholic who drinks all the time, you won't wake up the next morning to blow a 0.221. It's impossible.
Exactly.
But you did. And we have lab, right, Mr. Renicky?
We have a lab.
What does lab say? Where they tested it with scientific stuff.
I didn't mean to put you in a bad mood.
0.19. You did by starting by being late.
I
Okay.
apologize.
You're not supposed to be late to court. Okay. You're supposed to be here early so you can meet with your attorney. And quite honestly, and it's taken you months and 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 months.
Here's the key takeaway. Science beats excuses. The roadside test said 0.22, but the official lab still shows 0.19, more than double the legal limit. That's all the prosecution really needs. Viewers, do you think the lab results should always outweigh field tests?
To do the IDIP program. I gave you yet another chance. And now you're here debating.
I'm just
Science.
saying, anytime you put a numeral behind the decimal, like one numeral behind the decimal is a tenth. Two numerals behind the decimal is a hundredth.
Yep.
Three numerals behind a decimal is a thousandth.
Yep. I know math.
Okay. And a thousandth is 10 times less than a hundredth.
Well, let's cut that off. Okay. You blew a 0.22 with a PBT.
221.
Or 0.221. Okay. So let's say you will cut off the one because that's what math does. You get to cut off certain things. So you were 0.22. We'll give you the benefit of the doubt. No more with that one, that thousandth gone. So you blew a 0.22. But lab came back and said, guess what? We ran his blood, which is more accurate. And it gave us a better truth of what happened. And it was 0.19. 0.19. It's 0.08 in Wisconsin to be legally intoxicated and operate. So you get it now? You understand now?
I don't understand how a thousandth is a hundred.
I cut it off. I agree with, I'll give you the benefit. I cut that off. It's 0.22. It's 0.22.
No, if there's three numerals,
Yeah, I think
because if it was point,
Mr. Renicky, I'd love to have a jury trial because it sounds like he doesn't understand the science and he wants to have a lab analyst here. Is that right, Mr. Keene? Is that what I'm hearing? He wants to have a jury trial because we can facilitate that next week.
I'm just saying what math.
I had a jury trial come up, not next week, the week after. We can get a jury trial. Is that what you want? You want to fight that issue of this extra thousandth in the decimal point?
It's not an extra thousandth though. It's a thousandth or it's not.
Okay, it's a thousandth or it's not.
Yeah.
You want to go to trial over that and have the lab analyst explain it? Because I'm going to tell you, she is far smarter than I am when it comes to science and to explain it to you. Then maybe you'll be able to understand. You won't be able to ask her questions.
How about this? Can I just go to jail and I'll give you this copy?
I don't need the copy.
Okay, and then just so give me the knowledge because I like math and
Here's what you can do to gain knowledge. Call up a lab analyst, have them explain it to you. Because that's what happens in a jury trial. And I hear it. It goes on for hours.
I'm not trying to
hours.
piss you off. Just take me to jail. I'm fine with that. I have the money finally at the last moment. You've been very giving, lenient with me and gave me extensions. You're fair. And I'm here. And I'll go to jail, get out. I got a job.
All right. So are you admitting that you at least blew over a 0.08 or at least 0.08, at least blood alcohol content was in your blood at the bare minimum?
I agree that I blew a 0.221 and I agree that my blood alcohol was at 0.190.
Okay. All right.
I agree with those.
And do you agree that you operated or drove a motor vehicle in that state?
I agree to that, yes.
All right, Mr. Keene, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats to you, Mr. Lamprecht? Any promises for you to plead guilty to this charge? Has anybody promised you anything? Hey, we're going to give you $1 million if you plead guilty. Or we're going to give you some kind of benefit if you plead guilty, other than this offer of guidelines.
The only thing that I've been told was that I can get out, keep my job, keep my place, and keep my things.
Okay, so that's not a promise. Anyone threaten you anything? I'm going to beat you up. I'm going to take a gun. I'm going to take a knife. Anybody threaten to hurt you or anything?
None of those.
Okay. pleading guilty with a full understanding of what you're doing here today?
Yes, I'm pleading guilty to blowing a .221 and having a blood alcohol content of 0.190.
All right. And you're pleading guilty voluntarily.
Yes.
Does anyone or are you satisfied with your attorney's services?
I guess 5 out of 10.
5 out of 10. Has he done a good job in the fact that he's looked to see if you had defenses? Because I'm going to tell you, your argument here is crap.
And there it is, the official guilty plea. After all the math lessons and shrimp stories, the defendant admits guilt. But here's the twist. The third OWI is still a misdemeanor. One more, and it's felony time. Do you think repeat offenders should face harsher sentences sooner?
I don't say crap in court, it's crap.
I'm just trying to conversate. I'm not trying to argue.
This isn't a conversate time, okay? This isn't a time to conversate.
Okay.
This is a plea and sentencing in which you showed up to court 18 minutes late.
Okay. I forgot my money. I apologize.
Has your attorney talked to you about the case?
Yes.
And has he looked at everything and discussed with you everything that he's seen in discovery?
Except for my one question.
All right. Because he's not a scientist, but he said you can figure that out. Talk to a scientist, right?
I don't know any.
Mr. Keene, you said that's not a defense, correct?
And yes, and we have discussed that in basic math and other things along with it extensively.
All right. Okay. You have any? No. All right. So based on this, the OWI third, count 1, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be merged and dismissed with count 1. A judgment of conviction will be entered today. Mr. Renicky, argument, please.
This is kind of amazing, but in any event, this is an OWI. There was bad driving, but no accident. As the court is aware, it's a .19 BAC. This is his third OWI. He did complete the IDIP program. He still has to, at least at the time of my letter from Tessa Anderson, he had just dropped off the last $200 to complete the IDIP. But he needs to come up with a down payment for the electronic monitor as well as the booking fee. He was booked and released, so he has not set the 48 hours. Because of the IDIP completion and consistent with the plea agreement, we would ask the court to follow the IDIP guidelines for the 1-9 on the third offense, which I believe is $1,911 for fines and costs. That's a blood draw, so there'd be a $10 blood draw, 45 days of jail, 24 months of ignition interlock, 75 hours of community service, and 24 months of revocation.
Mr. Keene.
Yes, sir. I think this agreement recognizes both that alcohol use is an issue in the community. It has provided some rehabilitation needs because he has done some community service to, deal with the harm to community. Although again, no accidents happened. He was, for the period of the IDIP, which is longer than normally, done by the court by a substantial factor, had to blow into a tube and verify that he was not under the influence of alcohol. He also, as with an OWI 3, he would have a blood alcohol content restriction of 0.02, which means, I'd be careful about even non-alcohol alcohol, because 0.02 is nothing for the next 2 years. And it does have the future deterrence because any OWIs after this are felonies with a minimum of 1.5 years in the Wisconsin state prison system, because OWI 3 is the last one. It's still considered a misdemeanor. So I think that although it was a painful process to get here, the court should stick with the agreement because, it a pain, but Mr. Lamprecht has met the terms of the IDIP, albeit not in the normally prescribed time. The agreement does serve the goals of trying to get pre-sentencing rehabilitation done, and there's substantial deterrence to protect the community's interest because of just the fact that it's an OWI 3 and the ignition interlock provides that for 2 years plus the substantially greater penalties on any future sentences. So I would ask the court to stick with the agreement despite the, less than beneficial behaviors at times exhibited by Mr. Lamprecht.
Thank you, Mr. Lamprecht. Anything you want to add or say to the court?
Nothing that I haven't already.
Well, I mean, what are you doing employment-wise and stuff that you're trying to help in the community?
Yeah, I have a job.
Okay.
He has a job, he has a life, he
Yeah.
is there waiting for him after he's done here today, which is all a positive thing.